So I have some major news that you're going to want to stick around for. An emergency application has just been filed to the Supreme Court in the case challenging the state of New York's new concealed carry laws, which they passed in direct defiance to the Supreme Court's recent ruling in Bruen. So let's talk about this. How's it going, everyone? My name is Anthony Miranda. I am a licensed and practicing attorney in the state of California with an emphasis on Second Amendment rights. I've been part of Second Amendment litigation both at a state level and a national level while serving as a staff attorney with the Firearms Policy Coalition legal team. My goal with these videos is not to provide you any legal advice, but instead to give you greater insight into the inner workings of Second Amendment litigation and help you understand what's currently going on in the battle for our right to keep and bear arms. As I mentioned in the intro, in this video we will be discussing some major news. Gun Owners America, or GOA, has filed for an emergency application for immediate administrative relief in the case challenging the state of New York's new concealed carry laws, that law being the Concealed Carry Improvement Act, or the CCIA. The case we're going to be talking about in this video is called Antioch v. Negrelli, or just Antioch. If you don't recall, GOA sued the state of New York because of the new concealed carry law which they passed, which was in direct defiance to the Supreme Court's recent ruling in New York State Rifle and Pistol Association v. Bruen. In Bruen, the Supreme Court struck down New York's May issue licensing scheme, finding that it was inconsistent with this nation's history and tradition. One of the primary findings of the Bruen decision was that the government bears the burden to prove that their restrictions are based in the history and tradition of our nation. But another important thing that the Supreme Court did in that decision was they stated a state like New York cannot simply make everywhere within an entire state a sensitive location. However, despite that decision, 8 days later, the state of New York rushed through a new law called the Concealed Carry Improvement Act, or the CCIA. Instead of rolling back their concealed carry laws, the state of New York doubled down on all of their gun control and created a carry permit scheme that was even worse than the one that existed prior to Bruen. Because of how this law directly violated the Second Amendment and also what the Supreme Court said in Bruen, GOA filed a lawsuit in the state of New York in a federal court, and the case ultimately went up before Judge Sotheby. And Judge Sotheby, in that case, heard GOA's request for a preliminary injunction. And ultimately, he did grant that request for a preliminary injunction against various aspects of the Concealed Carry Improvement Act. In that decision, he struck down portions of the law like the whole good moral character standard that was in the law that New York passed, and also the whole catch-all sensitive location restrictions. Well, of course, the state of New York was not simply going to take their loss and go away and kind of lick their wounds. Instead, they decided to appeal the grant of the preliminary injunction up to the Second Circuit, and also they requested that the Second Circuit place a stay on that judgment from Judge Sotheby. The Second Circuit ultimately granted that stay, which prevents Judge Sotheby's preliminary injunction from having any impact and ever going into effect. This means that the state of New York gets to enforce their Concealed Carry Improvement Act and that law essentially until the Second Circuit decides that they finally want to hear the Antioch case, hear it on appeal. So while that's all in place, a stay is currently in place, halting the preliminary injunction from taking effect, and the state of New York continues to be allowed to defy what the Supreme Court said in Bruen and just do whatever they want with their new concealed carry laws. Well, instead of waiting on the Second Circuit to do the right thing, GOA has filed an emergency application up to the Supreme Court. The emergency application asks the Supreme Court to vacate that Second Circuit's grant of the stay. This is a significant move because it aims to quickly stop all the state defiance, the lower court defiance that has popped up after that Bruen decision. So let's take a look at the emergency application that was filed by GOA up to the Supreme Court. The opening of that application states, without providing any analysis or explanation, the Second Circuit has stayed a preliminary injunction issued by a federal district court in New York that was carefully designed to limit New York's enforcement of a sweeping gun control statute enacted as retaliation against New York gun owners for having prevailed in this court's decision in New York State Rifle and Pistol Association v. Bruen. The district court's injunction was supported by a detailed 184-page opinion, meticulously tailored to follow this court's framework established in Bruen. In contrast, the Second Circuit stay pending appeal was issued based only on a single conclusory assertion, yet with the effect of indefinitely suspending the protections afforded New York's by the Second Amendment and affirmed by this court in Bruen. The Second Circuit stay should be vacated in order to uphold the right of New Yorkers to keep and bear arms, as well as to vindicate the authority of this court over the circuit courts. So GOA argues that the Supreme Court should vacate the stay that was granted by the Second Circuit because without the vacature, New York will be allowed to violate the Second Amendment rights of those individuals within the state, and also without the vacatur, the states like New York and circuit courts will be allowed to continue to outright defy what the Supreme Court said in Bruen. This application was filed to Sonia Sotomayor, who is the justice responsible for reviewing emergency filings which come from the Second Circuit. If you're not aware, justices are kind of in charge of various other circuit courts, so they will hear these types of emergency applications and a justice is assigned to each circuit court. Sonia Sotomayor is responsible for the Second Circuit. Now you may be thinking to yourself at this point, well, that means nothing's going to come out of this because Sonia Sotomayor is liberal and she's not going to grant this review. But that's not the case. If you look at the Supreme Court's Reporter's Guide, they outlined very clearly how this process will actually work. It states that there are several possible scenarios for how this can all play out. First, Sonia Sotomayor has a few options. She can grant or deny the application on her own. The third option is she can refer it to the full court for a vote. Now, I know a lot of us would say that she will just simply take it on her own and deny the application. If that happens, you will see this case eventually just pop up on the docket and it will just simply have a denial with no explanation. And that's what would happen if she takes it up on her own and doesn't refer it to the full court. But that's not where this stops. That doesn't end this whole issue. This part right here is very important, so pay attention. If a justice acts alone to deny an application, a petitioner, here being GOA, may renew the application to any other justice of his or her choice, and theoretically can continue asking justices until a majority of the court has denied the application. So the reality is, yes, Sonia Sotomayor may decide to act on her own and deny the application. But even if she does, then GOA can go to any other justice, anyone that they want, let's say Justice Thomas, and ask him to take up the application on his own. And the odds are that Justice Thomas would do that because he's probably not very happy with how states like New York and lower courts, circuit courts like the Second Circuit, have refused to follow the Bruen decision that he authored. Since the inevitable is that GOA will likely go to Justice Thomas if Sonia Sotomayor denies the application on her own, I think it's much more likely that she will just simply refer it to the full court for a vote on that application. She doesn't have to, but I think all roads point towards a full vote by the court anyways, so she just may simply cut her losses and refer it to the full court right now at the beginning instead of going through all the rigmarole knowing that ultimately this is likely going to make its way to Justice Thomas, who's going to do this anyways. But along with any order to vacate, the Supreme Court can issue an opinion with that order, which if that happens, I don't foresee someone like Justice Thomas holding back any more on writing that type of an opinion. His Bruen decision was very clear and stated that this type of conduct, which makes an entire state a sensitive location and creates this type of scheme, is indeed impermissible. But New York and other states thought they could get away with this, and ultimately they're going to have to face the consequences. What is happening here with this emergency application is very important, not just for the state of New York, but other states as well, like New Jersey, who just passed a similar clone bill, and also California, who is aiming to do the same thing. If the Supreme Court vacates the Second Circuit stay, that will give these states and circuit courts and lower courts major pause because it will show that the Supreme Court is no longer going to permit them to outright defy what the Supreme Court said in Bruen. So this is something that's very important. Also, one of the good things about this is that we don't need the whole oral arguments. We don't need a bunch of briefing on the emergency application. Instead, a justice or the court can grant it. They can do it anytime. They don't need to do all that other stuff. So really today, tomorrow, anytime that they want, the court can issue their order. They can vote on this, grant the application, and ultimately vacate what the Second Circuit ruled. So this is something I'll definitely be keeping my eyes on. If I get any more information, I will let you all know. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of two-way news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And don't forget, this is just Built by Armed Scholars, and this station will be maintained by Armed Scholars.